Harry calls me in a panic on my cell phone. Very few clients have my cell phone number. I'm here at Charlie's apartment where Patricia was staying, and there was a little fire. She's dead.
What?
Hi, this is Jeff Marsacci, the Plain English Attorney, and welcome to the video. Before we dig into today's topic, please help us get out solid, accurate information on estate planning and Medicaid planning by liking the video and subscribing to the channel. Unfortunately, the algorithms just tend to favor videos that tell people what they want to hear instead of what is actually true. If you want us to get the truth out there about estate and Medicaid planning information, then please like the video and subscribe to the channel.
Now, one of the questions I end up getting asked is, what is the worst horror story estate I had ever been involved in?
Oh dear.
Well, this is the story of Harry's friend Charlie. Harry and his wife were longtime clients of mine at this point, and this is going back several years. He called me up and said, I know we've got all of our stuff done, we're all set, but my best friend and co-worker, Charlie, well, he died, and it was a sudden thing. We were out playing golf. He said he felt a little tired. He didn't want to sit down and get lunch with the rest of us. And then one of the servers came running into the restaurant and started dragging me out. Behind the wheel of the car, there's Charlie, dead of a heart attack. Car is in gear and his foot is jammed on the brake. 57 years old.
Oh my God.
And so it's like they're asking me at work, what do we do with his final paycheck? What's going on with his 401k? He's got some insurance. What do we do? It's like, well, not married? No. No kids? No. Parents alive? No. Both parents died a few years ago. They were up in New Jersey. Their estates are still open, okay? Does he have any siblings? Yes, he has one sister. Okay. She's kind of the person who's in charge because he had no plan. So Patricia came down from New Jersey. I started explaining the probate process to her. She's like, I can't do this. Harry, can you do this? So she goes to can you be the administrator? It's like, I suppose I'll do it. This was my friend. So we get all the paperwork, send it in. It gets approved. And then a few days later, Harry calls me in a panic on my cell phone. Very few clients have my cell phone number. He called me on a Sunday. I'm here at Charlie's apartment where Patricia was staying, and there was a little fire. She's dead.
What?
She had left a cigarette burning in an ashtray on the couch. The couch caught fire. Now, thankfully for that whole apartment complex, it didn't catch fire, but all the oxygen got sucked out of the room, and apparently she was lying down and taking a nap, and that was it. Suddenly, all the cousins start coming out of the woodwork. Charlie had this, I want this, I know he had this, and I want that. You give me this, whoa, wait a minute. And then I had to explain exactly what happens when there's no plan and nothing's written out. First, Dad's estate was still open. Mom's estate was still open. Half of each estate has to come down to North Carolina and get combined with Charlie's estate. Meanwhile, Patricia's still entitled to half of each of the parents' estate, but she's a resident of New Jersey, even though she died here, so you got to set up an estate there. And since Patricia is Charlie's heir, when we get his estate settled, which can only happen after the parents are settled, we'll send everything up to Patricia's estate in New Jersey. It's got to be at least a couple of years before you get anything. So this is what happened when there's no plan. How many people here have an estate plan? Everybody should be raising their hands, because even if they don't have an actual plan that they put together, the government has a plan for you. It's probably not what you think.
If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel.
How many people here think that just because you're married, your spouse gets everything? Now, nobody's going to raise their hand because they're... Marriage as an estate plan is like Scotch tape. It's not really ever going to do what you think it's going to do. In North Carolina, if you are married and there are no kids but the parents are alive, parents are getting half. Oh, what if there are no parents but there are kids? If there's one kid, the spouse gets the first $60,000 of personal property and then half. Oh, what if there are two or more kids? The spouse again gets the first $60,000, then they get a third, and the kids split the other 2/3. Wait a minute, that doesn't sound right. Well, that's the plan that the government has kind of laid out, and they had to balance a whole bunch of things. And this isn't the same plan that is in other states. Every state kind of has their own thing laid out. The only time that a spouse inherits everything is if there are no parents or grandparents, there are no kids or grandkids or any further down. All it is a spouse, okay, that's the only time they get 100%. So if you want something other than that, then you need to put together your own estate plan. One of the big questions we always end up getting at the start is, what is probate? How many people here have experienced probate? I'm so sorry. I'm sorry that you had to go through that. Probate is essentially a court process that oversees the administration of an estate. Well, what exactly does that mean? What goes into probate? Right. Probate will take a hold of any assets that are still titled in a deceased person's name. So it will take a hold of them. You have to file all these inventories, provide all this proof. Here's what this was worth. Oh, there were expenses of the estate. Well, okay, well, we need to see the invoice. We need to have a copy of the canceled check front and back. We need to see it itemized on the bank statements, and then we can approve it or not approve it, and it goes through this whole big churning of paperwork. And then it comes out on the other side that it goes to the beneficiaries. Oh, well, wait, what if I have a will? Well, a will determines what those beneficiaries are. If you have ever heard, oh, I have a last will and testament, my estate avoids probate, that's 100% wrong. The will only covers what goes into probate. So how do my clients try to avoid probate? Well, this is where we're talking about what's the base of your estate plan. Is it a will or is it a revocable living trust? How many people here have heard of revocable living trust as a way to do? Okay, good. That's actually a lot more than I usually see in workshops. A revocable living trust is just something that you're setting up where you're the trustor, you're the trustee running it, you're the first level beneficiary, and then everything that you normally expect to see in a last will and testament, this person gets it, if this person passes on, here's where it goes, if we're going to have any age limits, who's running this whole thing. Well, all that is in the trust. But now assets are either titled in the name of the trust, or it could be paying on death into the trust. And so everything that is in the trust, after someone's passed on, it doesn't go through probate because it's not titled in the deceased person's name. What we help people do is put together their revocable living trust and go through, here are what your assets, here's what your accounts are, here's how titling works, here's how beneficiaries work. There is this thing about, oh, you can just have an account as joint with the right of survivorship. Have people heard about that as a way to avoid probate? Has anybody told you that? Or, oh, well, I can just name beneficiaries on my account. Well, it's a little better than Scotch tape, but I call it duct tape estate planning. Well, why? Because it's usually good for one, maybe two transfers. And with life being the way it is, we never know what's going to happen. So here is a very common distribution setup for a lot of my clients. I'm married. We want everything to go equally to my kids once both of us are gone. Okay, very common. What if one of your kids passes on? You've got 3 kids. One of them passes on before you do. Oh, I want their share to go down to their kids. Okay. You can do that on a beneficiary designation for life insurance or accounts. And I list everything goes to my children equally per stirpes. Per stirpes. Yeah, that's one of the only few useful legal Latin terms that's still around. So all the other ones is probably a better way to say it. But per stirpes means it goes down through the bloodlines. Oh, well, how old are the grandkids? Oh, they're 3 and 5. Okay, when do you want them to inherit that? Oh, well, I put in my will that they got to be 30 or 40. It went through beneficiary designation. They're going to get that money at 18. So it's not going to handle those contingencies. If you do all of that inside a revocable living trust, you can go many layers deep. In fact, some of my clients kind of get a little upset. It's like, oh my gosh, you keep killing off all of my loved ones in these scenarios to see where the money goes. If we get to this point, I don't know if I care. Well, okay, that's fine. We close up whatever those loopholes are. But I have seen too many things in my time as an attorney where an underage beneficiary not only wasted the inheritance, but it kind of ruined their life. Now, this one's a story that's going back at least 15 years, and there was a financial advisor who was asking, is there anything we can do? And unfortunately, there wasn't. He had been trying to get his clients to come to me to do their planning. They never did. They had one daughter. She was just a few months short of being 18. Car accident. Both the parents died. But they had listed on their stock account, which probably in today's dollars would be about $1.5 million. They had their daughter listed as the beneficiary. So she just had to wait 2 months. She gets the money, drops out of high school,
Oh, no.
marries an unemployed 25-year-old man. She buys a big expensive house that she can never really hope to afford and keep up over time, and then has probably the equivalent of $200,000 in the bank and says, I've got $200,000 in the bank. I'm never gonna have to work a day in my life.
Oh,
So not only was that inheritance wasted, it really did ruin her life.
oh dear.
So if instead it had gone into a revocable trust, or gosh, even if it went into probate and there was an age limit, at least it wouldn't have done that. So these solutions that sometimes seem really easy, like, oh, I'll just put my kids on as the beneficiary, may not handle all the contingencies that you want it to do, like a well-coordinated plan can. But I'd like questions at any point. I've got more material to go through, but if you've got questions, please interrupt me with them. This is actually one of the great things about a revocable living trust that's set up the right way. It doesn't interfere with what you're doing. There's no registration of it as a document anywhere. Not here. I think there are like 2 states that require a revocable living trust to be registered. It's not doing anything different on your taxes while you're alive.
Right, that's what I mean. It's like it was like
Yeah.
on paper, but it didn't really seem real in a way, because then I couldn't go to, say, the bank accounts and say, okay, the beneficiary now of all the stock and blah 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 is the trust
Well, if the account
kind of thing.
is titled in the trust, there is no need for the beneficiary. The trust already owns it.
But what's the trust? It's
All right,
not
think about it
anything.
this way, because you brought up businesses. If you have a limited liability company,
Right.
and you've got an account that's titled in the name of the limited liability company, and you've got inventory that's on the books for the limited liability company, where is the limited liability company? All it really is your operating agreement. Your business document says, here's how everything is run. Here's who the people are who are making things happen. It's just the document.
Right.
But
it's
it
registered with
describes.
the state. I mean, and I have a little certificate on the wall that says this is my
Yeah.
number, and I have to take that piece of paper to the bank in order to get a checking account.
And you've got your trust document?
That's good enough.
That's good enough.
There we
Yeah. You don't even need a separate taxpayer ID number until somebody passes on. If it's done right, it is. Now, here's the one thing that I end up seeing not done over time. I describe to my clients that when you're setting up a revocable living trust, this is your suitcase for your final trip. And I, as the attorney, I can craft you the best customized suitcase to fit your situation. So when you go on that final destination trip, you grab the suitcase, you check your luggage, you get on the plane, you take it out, you get to the hotel room and you open it up and there's nothing in there. You can't scream at the suitcase because you didn't pack it or you didn't keep it packed. So trust funding, making sure on an ongoing basis that assets are titled in the name of the trust, where the beneficiary is set up to pay into the trust the right way. All of that has to keep happening. I've realized the older I get, the more stories I get. This is probably going back more than 10 years, maybe as much as 12. This was at a point where people were still taking a lot of cash out of ATMs and using cash for transactions. And Wells Fargo, I think it was, came up with this brilliant idea. Oh, let's charge a $5 a month ATM fee for anybody who has a checking card linked to a debit card. And then we won't charge them per transaction. Well, there were a lot of people who didn't take money out of ATMs and they're like, you're charging me $5 a month and I'm never using, and they went absolutely bananas and started pulling their money out. I think this lasted about 6 or 7 weeks before Wells Fargo said, okay, we're kidding. And they stopped. But when I met with my clients for their annual review meeting and we went through, okay, what assets did you have? Oh, do you still have the Wells Fargo assets titled in the name of the trust? Oh no, did you hear what they did? Oh yeah, I heard what they did. Well, we were so mad, we walked right out, took all our money, and we went to First Citizens. Did you set up your new accounts in the name of the trust or in your own name? We were so upset with Wells Fargo, we opened those accounts in our own name. Okay, those needed to be titled in the name of the trust. That's the more ongoing thing that you're going to have to do with the revocable trust. It's also an unfortunate thing that there are a lot of attorneys when they do estate planning, it's more the ones that do it as a side gig. Oh yeah, I do divorce, but I can do some estate planning documents. They don't emphasize the trust funding as part of it, and so they send you the document drafts, it comes back, okay, sign it. Here's a little packet with about 5 pages that says you need to fund your own trust, and then they never mention it again. We really do emphasize that. In fact, part of our process, we have a separate meeting just to go over trust funding, and we give written recommendations and walk through it. And then at the annual review meetings, we talk about and make sure that the trust is funded. I have had a lot of clients who neglect that annual meeting, and it's 6 or 7 years goes by. When they come back in, about a third of their assets are no longer in the trust, and they need to go ahead and get on top of that. So that's the big one. A will is if it's the base of your document, it covers what's in probate. So if you want what is in your will to control what happens with your estate and where it goes, then you really should have as much as possible go into probate so that the document covers it. Oh wait, probate is something I want to avoid. Well then, okay, do a revocable living trust and make sure as much as possible things stay out of probate. Okay, we'll go ahead with the question.
Why would someone choose an irrevocable trust over a revocable?
Okay, good question, a little more advanced. Why would people choose an irrevocable trust over a revocable one? Revocable trusts give you complete control. It avoids probate. It's really just for that estate planning aspect. Another thing I should probably mention with the revocable trust, it doesn't just happen when you die. If you become incapacitated, you don't need to run and get a guardianship for anything that's inside the trust. Your successor trustee, with the way we do it, 2 doctor's notes saying you're incapacitated. They can step in and manage stuff. An irrevocable trust, there's got to be some other overriding reason, and usually, for a lot of my clients anyway, we're trying to secure their assets for a 5-year look-back period for Medicaid and want to start putting their assets into an irrevocable trust. But this means if it's going to be off the table for Medicaid, it's kind of like you're walking away from it. So maybe one of the kids is your successor trustee in the revocable trust. No. You're putting money in an irrevocable trust, or we have another special one for real estate. You're moving it in there and you're giving up complete control. So if you want money, you've got to go to your outside trustee, one of your kids, and say, can you please give me my money? And they get to say no. Whoa, wait a minute. Most of my clients are like, I don't want to do that. I don't think I'm ever going to want to do that. When you start looking at, okay, there might be this possibility of nursing home care being needed and it costs anywhere from $10,000 to $15,000 a month, okay, things might change a little bit. But that irrevocable trust really means you're giving up some kind of control in order to get the benefits of it. And the big thing, you can't change it. There's a way, a complicated way. It means you set up a new irrevocable trust and the trustee moves the money. But basically you should be looking at it as something that you can't change. Usually it's lawsuit protection, giving up that control so that it's not subject to a Medicaid spend down. There are some other particular goals that people might have with an irrevocable trust, but usually giving up control of your own trust is one of the things that's a hallmark of it in order for it to have those kinds of protections. So I'd have to actually look at the document and see exactly what it's doing. Yeah.
So are you recommending revocable trusts?
If you're doing estate planning and that's your only purpose. Usually when I'm sitting down with clients and we're talking about should we do a will or should we do a trust, and something comes out with, oh yeah, we're doing this estate planning now because my husband just got diagnosed with early stages dementia and we want to make sure this is all in place. Okay, hold on a minute. We'll talk more about the effects of an irrevocable trust, talk about potentially giving up control, and weigh the pros and cons of it. But most of the time, when my clients are just doing the estate piece of it, it's a revocable trust. There are some other documents that have to go along with the revocable trust because it's not just the trust. We need a financial power of attorney. Now there are different names for it. A durable general power of attorney, a springing power of attorney, whatever. Those are just kind of distinctions put on by attorneys in different, again, code talking. Basically, it's a power of attorney that handles financial things. So this kind of works in conjunction with a revocable living trust if you're incapacitated, or in a lot of cases between spouses, it's just, okay, it's a convenience thing. Need to sign some loan paperwork and my spouse is out of town on a business trip. Okay, I can sign for them. It handles assets that are outside the trust. All right, so let me just give the biggest example of, well, shouldn't everything be in the trust? Well, no. Things like IRAs and 401ks. If you take an IRA and move it into a revocable living trust, the government says, thank you. You've withdrawn all your money. We want our taxes now, all in 1 year. Whoa, wait a minute. Okay, so that's outside the trust. We work with the beneficiary designations to either point to the trust, point to beneficiaries, point to specialized trusts, whatever's going to work, and save on taxes. But what if you become incapacitated? Well, your trustee can't reach out of the trust and into your IRAs and 401ks just because they're the trustee. Well, that's where the power of attorney document comes in. That also empowers them to do things like sign tax returns, apply for benefits, work with Social Security. All that stuff is handled through that power of attorney. There also needs to be a last will and testament. Well, wait, isn't the trust supposed to handle things? Yeah, we call this a pour-over will. It's meant to catch anything that does end up in probate. Hopefully it's not the clients who don't come to me for 6 or 7 years and a third of their assets just end up being outside the trust because they made changes. Maybe it's odds and ends stuff. I can't tell you when I go through the funding meeting with my clients, how many of them are like, oh yeah, that's right, I still have $200 in that credit union account because they gave me a great rate on a car loan 8 years ago. But that $200 they made me put in the account is still sitting there. Okay, so if that ends up in probate, look, it's just an account that has to go through that process. If you have the absolute nerve, and this is kind of the time of year to talk about it, if you have the absolute nerve to file your taxes and die before you get your refund, how dare you? The government only issues those checks in the name of your estate. So it will not go right to your trust. It has to go through that probate process. But if we can minimize what actually goes through probate, because the trust is funded the right way, great. But you still have to have that will. Well, who's the beneficiary of your will? Your trust. You don't have to list any of the actual beneficiaries. And really, here's the big benefit of that, because I've done enough estates that I see it, and I've seen attorneys do it. Well, okay, I want everything to go to my spouse. If they go before me, I want it to go to my 3 kids. That's all listed in the trust. We've got ages and all the other stuff in the trust. If you put all of that stuff in the will, I want it to go to my spouse, not my spouse, to my kids, and then if, equally per stirpes and whatnot, and age limits. All of that is a publicly filed document now. Prior to COVID, I actually saw the marketing people go into the courthouse and they start looking through the probate files and they start writing down names and addresses of people who are going to inherit money. And they're going to put you on the marketing list. Isn't that nice? They'll help you spend that money that you're inheriting from your parents' estate. If it's a pour-over will and it just says it goes to my trust, well then the trustee is the only name and address on file, and usually the marketing people just leave that alone. Nobody really needs to know and see who your beneficiaries are except your trustee and your beneficiaries. The public doesn't need to know. So that's why it's a pour-over will. It pours over into the trust. But I have seen attorneys use the will to distribute those personal items and personal property out. Now, when we set up a revocable trust, part of the paperwork is you are signing a form that moves all your collective untitled property, clothing, furniture, appliances, all that other stuff, it's part of the trust. And it's clearly stated, in the future, any other assets that I purchase are to be presumed to be going into the trust unless I have a specific writing that says otherwise. Well, why would you do that? You wouldn't. So technically, after you sign those documents, you go to the store, you buy food, you are purchasing trust assets. All that stuff stays off the table for probate.
Yeah, because it seemed like there was one piece of paper and I was like, shit, what do we put on this thing? It seems like everything's taken care of almost.
Yeah.
So,
yeah. And that's the way it should be. Nice and simple. So that's financially, trust or will, durable general power of attorney, pour over will. What about healthcare? Because that also comes up, and that's something that we do. We put together a healthcare power of attorney. So the healthcare power of attorney is who's stepping in if you become unable to make your own healthcare decisions. Here's what the default is. It's the same thing as, oh, who's your next of kin? Okay, what if you and your spouse are in a car accident and you've got 3 kids? Oh, well, all 3 kids are in charge together. I have a hard time finding 3 people to agree what to order on a pizza, let alone health decisions in a crisis. So we really recommend, look, name one person at a time. We've got one person, we've got a backup, then we've got a third person, so that you've got this kind of succession of people who are in charge. That's financial or for healthcare. At least 3 people. I really push my clients to do that, and if they can have more, great. So this way, one person is in charge at a time doing healthcare decisions. And we really make that healthcare power of attorney pretty strong. I sometimes see clients, well, I don't want them to be able to make this type of decision, or they must have this type of decision, and here is specifically what I want. It's like, well, okay. Anytime you start getting that specific and you're not trusting that person to make the best choices with the authority that they've been given, it's probably time to think about who you really want in those positions. The other danger of being too specific is that it really can end up causing something that you didn't intend. Has anybody here heard of like the 5 wishes document? It's like, no? Okay.
Heard of it.
Yeah, basically it's this great form, you go, you fill it out, and I had one client ask me to review his, and he put in the notes, no amputation. So, okay, why no amputation? Well, I'm a type 1 diabetic, and if they're gonna cut off an arm or a leg, I would rather they just let me go. Okay, so if you're unconscious and you get an infection right here in the pinky, and they could amputate there and you could be fined for another 20 or 30 years. No amputation in a legal document. That's it. Wait a minute, what's the better course of action? Look, you fully empower your healthcare power of attorney agents, and then you have the discussion with them. Look, if they're gonna cut off an arm or a leg, let me go. So when they're now faced with that, well, okay, they're unconscious, they got this infection, I think we just need to amputate there, they're gonna go, all right, I know that's not what they really meant, and they can make a decision. So that's the healthcare power of attorney. Give them as much authority as possible. At least that's my legal theory. There is one decision that we have a document for. It's the living will. This is the, okay, I have reached the end. I am terminal and incurable. I am in a persistent vegetative state. Well, what does that mean? Well, look, the doctors have their criteria for what that really means, but the easy way to describe it, they've tried everything they can. They don't think you're coming back. There's nothing they can bill for. Okay, that's it. If they then approach the family or even the healthcare power of attorney and said, well, they've reached this stage, but we can keep the body going on the machines and the nutrition and the hydration if you want. Most of my clients are like, no, if I reach that point, let me go. But at the same time, they don't necessarily want to put the emotional burden of that decision on anyone else. So that document says, here's what I'm ordering, take me off everything. Now, the living will, it might be different in different states. The one that I know, just because that's where I went to law school in New York, it doesn't say, here's what my decision is. It appoints someone specifically to make that decision, but look, that's the way New York does it. North Carolina lets you put that final wish in writing in the living will, and it's done.
Is that the same as like a DNR or not?
No. And I always get that question too. All right. A DNR is something from a doctor. I can't put together a DNR. What's the usual circumstance where a DNR is requested? All right, let's look at the extreme example. They've already had 4 heart attacks, maybe in their late 70s or 80s or even older. And look, if they have another heart attack and they use those paddles to revive them, all it's going to do is break some ribs, and they're going to spend another couple of weeks in agony before they die. I don't want to go through that, let me go. So they have that discussion with the doctor, and the doctor can put together the DNR. Here's the big practical effect when it comes to healthcare workers, and whether it's a living will or a DNR. If you're having a heart attack, you're in your house and someone's going, they've got a living will, they've got a living will. The EMTs are going to shove them aside and they're going to revive you. That's because the living will, legally, is in order to your physicians. Emergency personnel have a duty to revive you unless, look, the doctor ordered not to revive you. And usually that gets posted in a couple of places in the house, and the EMTs see it and they know. But that's something you have to get from a doctor. And it's, you know, if there's a circumstance like that, it's worth having that discussion with them. We also have a nomination of conservator document. And that's, I look at it a little more as a defensive document, because if you have the trust, you've got the power of attorney, you've got the healthcare power of attorney, there shouldn't really be a need to go to court and get guardianship. It's not the people you've chosen who are going to court to get a guardianship. It's someone else who's coming in and saying, I don't like what they're doing, I'm gonna go to court, I'm gonna become the guardian. All right. The trustee goes in and says, look, Your Honor, here we've got the trust, we've got the power of attorney, here's the people that are listed, and we have a healthcare power of attorney, here's the people they've listed for those decisions. And here, Your Honor, here we have a nomination of conservator that lists the people they want as the conservator of the estate are the same exact people. We have a conservator of the person, it's the same people as the healthcare power of attorney. Why should we do this? Now, we're in a state that has elected judges. I can't say, oh, this is absolutely what's going to happen, but I've met a couple of judges and I can't see them not going, yeah, I don't see why we should have to, quote, burden the court's time and the taxpayers' resources here. Let's just throw this out. Now, one exception to that, if a judge looks and sees, hey, trustees stealing money, I think we need to do something here, then very likely they would do something, but very likely they'd just go to whoever your second choice was, rather than necessarily the person who's yelling and screaming. So we always put that document in as one of the ones that goes along with everything else. And then if you do have minor children, all right, naming who you think would be a good guardian for them is something that you also should have. But it's never an absolute, because a judge always has to assign guardianship. And the older the kids are, the more of a say they have. But that's just another big document if it fits that situation. That it rounds out the list of the documents. Because I was going to talk about the big four estate planning decisions and how it really works. When you're doing estate planning, there are really four big questions that you need to answer. And I run through this with my clients. I think a lot of attorneys probably overcomplicate it by saying, oh, who do you want to be the power of attorney? Who do you want to be the trustee? Who do you want to be the executor? Well, wait a minute. If we put this all together and boil it down, if the first question is, who do you trust to handle financial things for you if you can't? If we put all of this together and you drive out and if it's you and a spouse, both of you are in a car accident, you're in a coma for 3 months. Somebody's got to grab the finances, pay the bills, move money around, keep everything going so that when you get out, you're not left with utilities turned off and things being repossessed. And if you don't make it out of the hospital, you do pass on, all right, who's in charge of making sure that everybody gets what they're supposed to get and when they're supposed to get it? And this is where we're looking for one person. If they can't do it, there's a backup. If they can't do it, there's a third. All right, that's the first. Second big question, who do you trust to handle healthcare decisions while you're in the hospital in that coma for 3 months? So who's going to talk with the doctors, decide on courses of treatment, sign all that paperwork, and make those decisions? Again, one person. If not, there's a backup. And then after that, there's a third just in case person, at least. And then the third big question is the estate piece of it that sometimes my clients aren't happy with. Who gets what, when do they get it, and how? And then I proceed to kill off their loved ones in various scenarios to see where the money goes and put things in a couple of levels, and we talk about age limits and things like that. And then the fourth question, a lot of my clients don't necessarily need to get to, it's who's going to raise your minor children if anything happens to you, right? So what exactly does that mean related to your question? Okay, that financial person, that list should be your trustees, your power of attorney, the financial power of attorney, the executor of that pour-over will, and the conservator of your estate. There's no reason that anybody has been able to explain to me ever why there should be different people in that list, because it's all kind of the same job. It's just before death or after death, or assets inside the trust or outside the trust. If you pick different people for your power of attorney versus your trust, think of it this way. How many people, I say Kentucky Fried Chicken, but it could be Bojangles, you've been to one of them and you've ordered. Imagine going up to the register, okay, I want to get a 20-piece chicken, but I want these 3 sides. Oh, I'm sorry. We can only take your order for the chicken here. You have to go to the other register to order the sides. Doesn't make sense. Same way it doesn't make sense to put one person in charge of your assets that are inside the trust, who are there to take care of you during incapacity. Put a different person in charge of your power of attorney to handle the assets outside the trust. You want one person and you want to give them the authority whether assets are inside or outside the trust. So that's why those lists kind of line up. And on the healthcare end, it's who's your healthcare power of attorney and who's the conservator of the person. It just goes across those documents. If you don't see a YouTube video from me in 3 or 4 weeks and it's like, wait a minute, okay, something probably happened.